Good morning, loveys. I'm so sorry. I could not remove my head from my ass with technical issues, per usual. And we're here, though, together on a Wednesday. And we have a lot to discuss. I have approximately 5 pages of notes from yesterday, and it has been quite the last 24 hours. And today is our homegirl, one of our best friends from out of town, Karen Reed's birthday. So happy birthday, Karen. And I'm going to do my best to be the unpaid, non consensual intern that you've come to know and at least tolerate. You know what I'm saying? Good morning. Good morning, Jamie Z. M says, happy birthday, Karen. We ain't got no quit. Hashtag free Karen Reed says, Nurse Kim, good morning. Oh, thank you so much. Curious. Are you talking to me or Kersey Nursey M? Is she here? This is beautiful. And I love that you did that, Christina. I sent a little Venmo to Karen this morning, just wishing her a very happy birthday. And I know that this will be the last birthday. I feel it. I feel it in my bones. And I know this is going to be the last hardship birthday for Karen that she has to get through. And as soon as she gets through this, the other side will be what she was meant to do on this earth, to fulfill the changes in the Commonwealth. This was what she had to sign up for. It was written in the stars. She didn't say, hey, choose me. It was already decided. And all of us coming together and the support and shining that light on the Commonwealth and the corruption will change the trajectory of Massachusetts indefinitely. And I firmly believe that. I know. Rachel says, God, I hope so. Keep the faith, Lovey. And Dorothy Walters says, happy birthday, Karen Reed. Okay, loveys, let's get into today, where I've had the time, because we know I have, I listened to the methodical, chronological, incredible, record-saving kind of argument from a Robert Alessi, one of our incredible defense team. And he needed to be the one that got up there, babes. And this is why it made sense to me. Judge Kenon was still flustered yesterday. Do we recall? Let's see. Let's throw her on the screen with us. And I just want to show you her. And you'll be like, oh, she was still flustered. She was still shaky in the beginning of the entire hearing. So I was like, oh, she's struggling. And I know that she was pissed off. It's like pissed offness to the nth degree. And Attorney Alessi was the one to get up there because she would have got pissed off at Alan Jackson and she would have got more pissed off at David Yannetti, because she always says that his hyperbole. I picked out some clips that she has really given him the business. And this is important. And it was traumatic for the defense to be accused of these actual violations of ethics. This wasn't Rule 14 that was being discussed in majority, in sum and substance yesterday. It was ethics violations. And you came for the neck of the defense. And then we see Hank Brennan double down. But he made a couple of missteps yesterday that I just want to point out. And I hope he is ready to choke on his words, figuratively, not literally. But he made specific comments that I want to parse out, and I know that the defense will parse out that transcript and absolutely shove up you know, where the sun don't shine and where the number 2 pencils live. Okay? We're going to give him a run for his money, babes, and we're ready to rock and roll. So in the first 5 minutes of this hearing, we knew everything that we needed to know. We knew that Judge Bev Kenon had not gotten her summer blonde or her spring blonde. She's not ready for spring training. What kind of woman are you? Okay? We should be down with the boys in Florida doing spring training. But she's still got the winter blonde. And I got my spring blonde on yesterday. We'll talk about that trauma afterwards. My poor hairdresser said, "Your hair is getting darker as you age." It offended me. And it took my hair because of the roots that I had, like 4 inches of growth. She's like, "Bitch, you cannot wait this long." And I said, "Trisha, I won't do it again." So Bev, make good choices and don't have to be under the dryer, under the heat with your bleach like I did. Oh, she forgot her pearls. Kelly, she did forget her pearls and she needed to clutch them. But we do know that at least 3 to 4 times she clutched her butt. She absolutely clutched her butthole. Yes, Karen Harris knows all about the spring blonde. Okay, so now let's get into it. Let's listen to this first 5 minutes of Judge Kenon. We're going to talk all the shit afterwards. And then we can't go through everything because we don't have time or emotional bandwidth to go through everything that was said. But there are specific parts that we have counterpoints and we're ready to fucking rock the socks directly off of the Commonwealth. Let's go. Mm-hmm.
Of a previously undisclosed relationship, perhaps, between defense counsel and the ACA witnesses. I took a recess here. I had heard about email communication, detailed communication, memorializing a conversation regarding an engagement letter and a promise of retainer on March 20th and 22nd of last year, roughly 2 months before the ACA witnesses testified. There is another email that was 2 days before the trial and after the voir dire, 2 days before the trial with a list of cases. The Sunday before the witness testified, there's a proposed script of questions and answers and suggestions. And after the trial, there is an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ACA witnesses were expecting to get paid. So the Commonwealth, I suspended for 3 reasons. The Commonwealth raised questions of candor with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity to reflect, to talk to each other, to look at transcripts, to consult with people. And that it made sense to give you some time to do all of that, because what the Commonwealth raised does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that entails. So,
just an FYI, babes, this was bullshit, and this was a bullshit off the rectus scale. I think that Judge Kenon had a minute. I think she rolled the tape back, and I think that she took a gander, saw herself, and said, "Oh, shit." That was visible. That was a visible reaction of myself. Embarrassing. So now all of a sudden you're going to say, "Oh, yes, this was all my pause was solely and primarily to prevent the defense from having to get up and discuss what happened and to answer to these allegations that I stopped an entire hearing this close to trial And I want to make sure that Karen has a right to a fair trial. Oh, save it, Beverly. Continue. Oh, JK.
It made sense to me to suspend first and foremost for that reason, so counsel can be prepared to make any comments if you choose to. Second reason is what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Ms. Giannetti, where I raised my skepticism about defense counsel in a murder case calling not one, but potentially 3 witnesses that you never talked to. I looked back at the June 18th voir dire hearing, the June 24th trial testimony of the ARCA witnesses, and the June 25th closing arguments of counsel. So after
Oop, and so did I. Okay. So did I, Judge Beverly Canoni. And we will be taking tiny snippets of them because I was very surprised to go through the specifically voir dire and June 10th trial days, and hear what was said, because there were specific areas that Robert Alessi, I believe, will use in a more, like maybe in a filing to specifically refer to, which only aid in the defense argument that there was never, ever, ever a coordinated, paid, relationship between ARCA and the defense team. And everybody knows that. And yet we're playing dumb. So, okay, let's go.
after reviewing that, and my memory was pretty good about that. But what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th. So 3 weeks ago, not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at Sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery.
Oh, and loveys, this is going to be my first. This is going to be my first stop, and I have another clip for us to play. God darn. Listen, you know me and you know technology. I ended up having to back up this stream because of my inability to be appropriate. But I wanted to play this when they said, okay, so Judge Canoni is saying, hey, bitch, you said about Alan Jackson, you guys told me that the Commonwealth had the same exact batch of information. Now, words matter, facts matter, journalism, 2025 trademark Nurse Kim. And we know that there is the only batch of information, the only report that was ever derived from ARCA came from a retainer with the federal government. Their report was furnished, and they handed that bitch in. Then the feds made an unprecedented move, and they released over like 3,000 pages to the court, to the Commonwealth, and to the defense. That batch of information included ARCA's report. And let's bring up a little ditty of Ms. McLaughlin in trial 1. And this is when they are discussing on June 10th the need for voir dires of both Dr. Rentschler and Dr. Wolf, as well as Marie Russell.
What the Commonwealth is entitled to under Rule 14 and what every criminal defendant in the Commonwealth of Massachusetts must produce to the prosecution. It was not until the day prior to trial on April 15, 2024, that the defendant provided notice of all their experts. During jury impanelment, the Commonwealth filed a renewed motion for reciprocal discovery, and the defendant was ordered within a week to produce the expert opinion testimony that the Commonwealth is entitled to. We are now entering, I believe, week 8 of the trial. The Commonwealth has not received any intended expert opinions, anything that those experts, any written reports, opinions, or anything that those experts have based their opinions on. Essentially, the defendant's strategic decisions not to retain their own expert, but rather rely on the U.S. Attorney's Office investigation, does not alleviate them or relieve them from their Rule 14 obligations.
Oh, I'm sorry, Ms. McLaughlin. Did you just say that the defense used the government, the federal government's their witness, and just because they did that, that expert that was retained and hired by the federal government, that they still have to comply to discovery in Commonwealth v. Karen Reed? Yeah, babe, but everybody had the same information. There was no additional information that has been proven, checked, verified, signed, sealed, delivered. I'm yours, okay? That's what was said. And the findings in the ARCA report were that Officer John O'Keefe's body was not struck by Karen Reed's Lexus vehicle, and Karen Reed's vehicle did not strike Officer John O'Keefe. Continue, Beverly, with your bullshit.
I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me. Jim, do you have a copy of that there that you can? And I made sure, so the transcript is of the entire hearing because I don't want anyone to think anything's out of context. So we will mark that as an exhibit. And the third reason I paused is because, frankly, I needed time to reflect. I don't know what may flow from.
Well, thanks for at least giving a shred of honesty, Beverly, that you needed time to reflect. You needed time to go in the back, potentially do some goat yoga, call Jim over, fix a printer together. I don't know what the fuck you did, but reflection you did need.
This, obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to be heard, I will hear from defense counsel.
And this was a moment that the first moment within the first, 5 minutes of Judge Kenon speaking, that I physically recoiled, my butthole clenched, and I said to myself, bitch, is she telling the defense to not rebut this? Is she saying, shut your mouth when you're talking to me? Did she say anything you say can and will be used against you in the court of law? Sure felt that way. But you didn't know what the fuck was up, did you, Bev? At this point, you didn't know who was coming. And you didn't know that Robert Alessi was about to slam the hammer like Thor. Right on the table. Gaveling that shit. Showing you how it's done. Protecting a record and stating every fact needed in order to show that if you want to fuck with the Rule 14 discovery issues and say that in a 24-hour span that the defense did not produce an email and an outline of questions that came from whom? Dr. Wolf himself to Alan Jackson, not the other way around. Now, that was on Sunday, the Lord's Day. Everyone should have been at church, but no, they weren't. You know what they were doing? I don't know what. Okay. Couldn't tell you. But the assholes were waiting in limbo and getting ready. I'm talking about the Commonwealth. And then the next day, the very next day, who gets up? Dr. Rentschler, Dr. Wolf, and the defense rests. On the 25th, then it is closing arguments by the Commonwealth and the defense. And then the jury deliberated for 5 days until a mistrial was declared by Judge Kenon on July 1st. So when in the actual fuck did you think, Judge Kenon, that Liza Little was going to say, ooh, that fucking email that Dr. Wolf sent to us that we didn't use because we had our own questions, but he just was like, throwing out some suggests there because he's a professional man, because he's a doctor. And usually when an expert is called, they are able to go back and forth and have some, conversation, any kind of prep, if you will. But this was a very unique case. They had known all the findings. They had known all the opinions prior to them even coming in for voir dire. Okay.
Your Honor, thanks for the opportunity to be heard. I am going to be
My king.
responding on behalf of defense counsel
Okay.
to all of your concerns. I have a notebook that I've given, albeit just now, to Mr. Brennan. It's got exhibits, but it's everything that everybody's already had. It's similar to what you're doing: transcripts, documents, probative issues. If, with Your Honor's permission, I'd like to provide you with the notebook so that you can follow.
That'd be great.
And should I hand it to someone here to have it handed to you? Bring it up.
A court officer will take it for you.
Okay.
I appreciate that, Mr. Alessi.
You're welcome.
Sorry. Ooh, she's getting better. I just wanted to remind you, babes, that this was the moment in which we remembered what a real man's binder looks like. Okay? Know what I'm saying? You got 8 tabs in there for us, Mr. Alessi? Oh, you want to hand them out to everybody? Unlike Hank and his little skanky binder that he's banging on a podium? Ew. I got the ick. Stop it. Continue, sir.
Thank you.
There's another note to follow along. And with that, Your Honor, I'm going to go to the podium and make my presentation.
Okay.
Email address. I will get that countersigned and returned to you forthwith, along with your.
Ooh, we're going to start right here, guys.
Becomes more sui generis, more ad hoc. And then there has to be sort of new ways of addressing the situation. That now brings me with that important background to tab 1. And to repeat, the communications start with a report from the ARCA experts and their findings and their conclusions that never changed. They never changed from the report they generated until the first communication in tab 1. It may seem self-evident, but given the moment, I'm not going to take anything as self-evident. The defense had zero input into the report and therefore had zero input into the findings. And in fairness to the Commonwealth, nor did the Commonwealth.
And this is where, babes, the rubber meets the road, okay? That's the crux of this entire argument. I don't give one shit what any troll wants to say to us about they were hired and paid for by the defense regarding ARCA. No, they weren't. Use your brain cells, the 2 remaining that you have in your skull, and note that everything that ARCA said was incorporated in a report that came to them. This is acknowledged by who? Ms. McLaughlin in the clip that I showed, where she says just because the defense utilized the expert of the feds doesn't relieve them of their Rule 14 discovery. That's it. Thank you.
So with that, we come to the emails on tab 1. March 20, Mr. Jackson to Ms. Please note that there is no CC to Mr. Yannetti. Why is that important? When we get to Massachusetts Professional Rule of Conduct 3.3A1, that fact is going to become extraordinarily important. So we have a communication, and it needs to be read in its entirety. Fortunately, it's short. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer, as required. I have the good fortune of dealing with experts probably every week. And this is classic foreign parlance. If it's going to be required, you always hope for your client they're not going to require a retainer. But the language is as required. As. Also, if you could...
I just would like to say, pat yourself on the back, Nurse Kim and all the loveys, because we called that last week. Once this came out from Hank, we said to ourselves, okay, as required, but it wasn't required. Keep on, good
Have
sir.
a copy of your Dr. Rensselaer's, Mr. TV. I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. At that particular point in time, there was no conclusion, no agreement, no knowledge that these folks would actually be testifying. There was certainly the hope, there was certainly the desire, but there was no agreement that they were going to be testifying. That was the
So was the federal protective order that was referenced by Mr. Yannetti that said it was, and it was specifically outlined in rule, could not prep with us for trial. Was that in effect at the time these emails were sent?
The answer is, Your Honor, and I'm going to get to it, but I want to answer your question.
I'd like you to answer my question.
Yeah, no, that's I wanted to say it. I'm going to answer it directly. What Mr. Yannetti articulated is the rule of the road, not prep, was not a rule of the road. That wasn't the rule of the road, and I have objective proof of that. The rule of the road was there would be no substantive conversations
Yes.
with the ARCA experts. Okay, that was it. But the answer to your question is I do not know whether the ground rules were in effect, but I can get you that answer, and I will get you that answer hopefully in moments during my presentation. But I do not know the answer.
But the long and short of the entire thing, though, babes, is that there was no prep. And although Judge Kenon, upon her very dramatic first 5 minutes, that opener, that was effective, I'll tell you that, she mentions prep. And in the bill, we'll hear later from Hank Brennan that it says prep. But you know what it doesn't say? Sure as shit doesn't say prep with defense team. Sure as shit doesn't say prep with Alan Jackson. And we know that they did write very precise invoice notes, right? Phone call, AJ. They, that they had travel, I guess, delays on their way to Boston when they were coming up for trial, not for voir dire. These were very specific notes. And them prepping for anything was likely done independently because they needed to, and they should be able to review their notes, their report, in order to be asked questions by the defense and the prosecution.
All right, go ahead.
And it's an important question, and it's an important answer, I understand.
Yeah. And Mr. Alessi did a beautiful job in honoring and being as kind as possible to Judge Bev Kenon. And unfortunately, that wasn't returned to him. He was treated poorly. He was asked to, hurry up, or how long is this going to take? He was also said it was incredibly rude, in my opinion, to hear Judge Kenon say, "It's been a very long day." Oh. Oh, it has? Your 11 a.m. start time, and you ended at 4 o'clock, and you had at least an hour and a half in breaks? Yeah, I don't see that as being an extremely long day and burdensome on the court. Hmm.
There's also going to be, that I'm going to get to in chronological order, Dr. Wolf on direct talking about nighttime visibility, work, etc. But if Your Honor could just please note the absolute raising of the issue of nighttime visibility and pedestrians affirmatively in voir dire. So that was voir dire, no restrictions, opportunity to ask whatever they wanted to ask. And as a highlight, the voir dire brings out nighttime visibility work. If Your Honor could please turn to tab 4. Tab 4 is the June 22nd, 2024 email, but it's important who it's from and who it's to and who's not on. From Daniel Wolf to Alan Jackson, subject Wolf qualifications. No David Yannetti on this email. And Your Honor, because I've said it so many times, Mr. Yannetti not being on the email, I can tell you from my own experience in this second trial, but this was, I understand, the first, there was a division of labor. There was a lot going on. This is now June. This is in the middle of trial. Everybody's got responsibility for their witnesses. So there's not collaboration going on. It's not the luxury I usually have at my law firm, where you're sitting in a nice big conference room and all the attorneys are sitting around the table all the time, let's say in March, etc. But clearly in June, the trial's going on. But they're dealing with their own witnesses at that particular time. So let's read it because it's short, but it's important. I'll repeat again. This was an email from Daniel Wolf to Alan Jackson. Alan,
Sure was.
At this time this morning, putting together a brief outline of my qualifications. I've also attached my D&T deposition in the trial parlance. I know it's nothing compared to Andy. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. I will try to work on some direct examination questions tonight. So I want to start with, without getting tech geeky about it, some basics, because these basics were not brought up and I believe led to confusion on February 18th. If you look at the attachments, every email, as we know, has a lot of information on its face. And one of it is you can always tell what goes along with the email.
That is so true. Sigh of the Beverly says she apologized for interrupting Hank later, right? But she never apologized to Robert Alessi. And this was very important, babes. Like, this is when Attorney Alessi is giving us the breakdown of the communication in between the voir dire, which occurred on June 18th, and the testimony of Arca, which was on Monday, June 24th.
So this is attachment Wolf-Qualls document. But what's the most important points, I think, to be gleaned from this objectively, Your Honor? Mr. Wolf prepared the document.
Ooh,
Mr. Jackson.
ooh.
No, I was well aware of that.
Okay, so
What snark, right? Like, Judge Kenon just hitting him with a 1 and 2. She's like, I already have my own binder. I don't need you to tell me how to do my job. I don't need you to tell me anything. Why? Because had Robert Alessi not laid out an incredible oral argument, guys, to protect the record in case this needs to go to appeal, Judge Kenon had already made up her mind, in my opinion. And he did an incredible job yesterday. There was nobody else who could have done a job as meticulous as Robert Alessi, hitting each and every point in a thorough investigation as kind of someone that's not as close, right? He now is part of the legal team, but he is not someone who's been there from Jump Street. Like David Yannetti, number 1. Then the incomparable Alan Jackson and Liza Little joined the team. So he got to go through this with almost as fresh of a set of eyes as possible, even fresher than Hank's. And we know that his eyes are not that good. Time to go get those bifocals checked, Hank. because you're fucking with the wrong people.
He prepares it. He sends it along to Mr. Jackson. And it's on qualifications. The next is, if you would just please turn to the attachment, which are the qualifications, etc. There's a comment, and these pages aren't numbered, but the questions are. If you look at 19, nighttime visibility work. And there was a comment, and this was referenced on the 18, but I'm going to come back to this. If you don't want me to say that, that's fine. That very testimony and that very point was elicited by Mr. Jackson on the direct that we're going to get to. There was no hiding of it.
I read that as well.
Good, thank you, Your Honor.
Oh, bitchy. See, now there are people, of course, the trolls and others that would say that he didn't need to go through everything. And guys, again, I don't want to keep saying the same thing, but this was all with the incredible forethought of potentially needing to appeal any decision that is made if in the event that Alan Jackson is removed and his pro hoc vice is terminated in this case, God forbid, there had to be every statement here. And yet, Judge Kenon, knowing this fact, still took it upon herself to belittle and to tell the defense, and specifically Mr. Alessi, I already have this information. I already know. Oh, okay, that's not kind. And that's not being a fair and impartial judge, in my opinion.
The next tab, and of course, it has the D&T of Dr. Wolf, his experience in testifying in court, et cetera, et cetera. I will indicate, Your Honor, that the information in terms of quals, et cetera, all of that, to me, would be basic questioning in a voir dire. Those questions, to the best of my knowledge, were not an issue of concern for the Commonwealth with regard to voir dire. I mean, inquiry, but again, that's what voir dire provides the opportunity for. So next we have tab 5. June 23rd is Sunday at 2:59 p.m. from Daniel Welch to Alan Jackson.
Sunday.
Subject Wolf Direct attachments.
And we pray.
Direct. So it's clear. And then if you turn the page, that is the attachment, is something that has no labeling on it, but I don't think anybody is going to misunderstand that this is what's being referred to in the attachment Wolf Direct. So all the topics that are in this direct were all in the report of our.
Uh-oh. Guys, can you hear this? It sounds low to me, but I can hear it. Can you hear it? Oh, this is not good if you can't. Oh, okay. Oh, look at Cursey Nursey M knows. My Nurse Kim's volume isn't modulated. I don't know if she knows how to do that. I do not know how to do that. I apologize, everyone. Okay, I'm wicked sorry. It sounds low to me, but I just hope you can hear it like a little. Yeah. Is there a modulator? Do I need to get a modulator or? Okay, okay, never mind.
Frozen in concrete report of ARCA. And we will get to this, but what I did was I went and compared this outline.
I did too.
Your Honor, there's one thing I've learned in the short time is that Your Honor is on everything. And the reason I am underscoring this is because it's going to come to an application of all the legal principles. So I very much and genuinely very much appreciate it.
And he does genuinely appreciate that. Okay, here we go. We want to just put this one. Oh, we're going to go here to be careful. Oh, we then are going to see the OnlyFan. Hi, OnlyFan. You're so far away. Doesn't anybody stay in one place anymore? Okay, sorry. Keep a day job. Okay, boom. 136. Oh, no.
To understand and get behind those verbs as to what the facts are.
I love it.
So if the information is not disclosed, then it's not only an impediment, it creates a position where there's an unfair examination. Really? What here occurred? It's not the ARCA witnesses that I have the issue with. That's number 2 of 5. The Commonwealth is not saying we have an issue with ARCA. And why do I keep repeating this? Because my conclusion is going to be ARCA should be unscathed. ARCA should be available to the defense. And I'm going to get to more of that in a moment. So it says it's not the ARCA witnesses that I have the issue with. It's the issue of the fact that I don't have adequate discovery. Those words, I don't have. The Commonwealth had for 5 days the very discovery that was being discussed that the Commonwealth didn't have. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. I agree with that. I agree completely with that. And we complied on the 12th. And it's for this trial that matters, Your Honor. Your Honor has commented before that this is a new trial. This is a second trial. I've tried unsuccessfully sometimes to talk about the baseline with the Daubert issues, and Your Honor has rightly commented, well, Mr. Alessi, this is a new trial. Point taken. Now, I wasn't at the last trial, but I've read the transcripts. That's an important point, Your Honor. Mr. Brennan has said before that he, earlier in these pretrial proceedings, that he hadn't had a chance to watch, hadn't had a chance, and believe me, I can empathize with Attorney Brennan on that. It's a lot to digest. He and I are both coming into this second trial new. So I appreciated the comments he had made before, but his
Oop, hilarious. You got us. Oh, and Mr. Alessi got a couple of these. Attorney Alessi got a couple of good zingers in, because you know when he's like passionate about something, because he hits you with a 1-2. Okay. But he also has a little hidden undertone snarky, babes. He said, oh yeah, Attorney Brennan said that he watched the last trial, and I can appreciate that. Yeah, I can appreciate that as a new guy, but he's not telling you what really happened. And he's not giving it to you straight, Judge Kenon. So I can appreciate what he's said, but that doesn't line up with what actually occurred. And as someone who has come into this as a new face, a fresh new face, if you will, I've been able to review everything. And this is what really happened. Woohoo!
comment here is I've read the transcripts, and I'm going to assume that for the very important topics he was talking about, he had read the transcripts. But again, that would be something that only Attorney Brennan would know. But it's an important point to point out. That was the representation. But I've read the transcripts. And then he goes on, and he, on page 55, he repeats what we went through about June 10th and what counsel for the defense had said. So I'm not going to cover that. He's just reading what I took head on before the break. And so we then turn to the continuation of the buildup, which is at the bottom of page 55. Attorney Brennan. Now, I have some familiarity with the federal government. Seemed to me, based on my
I hated that. I hated that from the February 18th hearing date, guys. I couldn't stand it. When he said, I have some familiarity with the federal government. Okay. Oh. When you're talking about this in the context in which he is, many people wouldn't know if you're not from home, if you are not a local. Even though Whitey Bulger was an incredibly large national story, he was literally #1 on the most wanted list for like 16 years, right under Saddam Hussein, for the crimes that he had committed against humanity. And Hank Brennan, was counsel for the defense and Whitey Bulger in that federal and state trial. The federal trial, rather, again, and there was a feeling of changing narratives, and I think that that's so funny to me. Not funny, haha, but funny like you're a fucking clown, Hank. Because when we look at the narrative that was spun in that federal case, where he represented Whitey Bulger, he did everything he could to distance and deny the fact that Whitey was a rat. Who gives a shit that he was a murderer, that he murdered women, that he was a terrible mobster, gangster, terrorized Charlestown? And he only was concerned about spinning the fact that he wasn't a rat, which he most certainly was, and worked with James Conley, an FBI agent. And you're talking about us spinning.
Limited experience, there was much more to the story. And the story is about interactions with defense counsel. That's what was talked about above. So I
Pardon me, Z, you are absolutely correct. And I should say that he killed women and more men. He killed far more men than he did women, but he was convicted of 11 murders.
called the federal government. There's no statement here. There's much more to the story. And I've got the discovery that the defense provided that told the complete story. So there was, and I'll tell you my impression from what is stated here, is that counsel made these representations, but the Commonwealth couldn't evaluate them because they didn't have information. So they went to the federal government.
Ooh.
So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. Another statement, so could testify. I was resigned to a Dewey letter.
Quick question. Ding, ding, ding. Did your antenna go up? Did your antenna go up hearing Robert Alessi say that Hank Brennan at the February 18th hearing said, I called the federal government and it didn't, like, I wanted answers and information and I didn't get anywhere. Later on in this hearing, guys, we are going to hear Hank Brennan get up and be disgusted, or appear to be disgusted at Robert Alessi for even mentioning that Judge Kenon could call the U.S. Attorney's Office and ask if there was that conversation after the bill was received from ARCA to Alan Jackson's office to find out, where did this come from? What in the oh my gosh, are we supposed to do this? We don't want to get in trouble. We didn't know this was coming. We were shocked by it. So they made a phone call. And the U.S. Attorney's Office said, you can pay that. Now, Hank admits that he has called the feds and tried to get information, but his stomach is turning. And you'll hear Judge Kenon say that she would never participate in an ex parte, meaning one party only, right? Conversation with anyone. So it is rules for ye, but not for thee. Ooh.
I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requested deadlines, I finally received a response that was unresponsive. This is talking about discovery and information about ARCA that was already in the possession of the Commonwealth. And it was striking that it was noted it was unresponsive just when I read the materials. I don't know which materials Attorney Brennan is talking about. I'm going to give Attorney Brennan on this one the benefit of the doubt that he's not talking about the discovery materials that we had provided, because I think fairly read in context, that's not what he was referring to, but I don't.
I love that. I love that about the defense. And it always has been this way, that they try to give the benefit of the doubt. And I had as well. I'm going to tell you this right now, guys. I'm no longer doing that. I am no longer giving the Commonwealth of Massachusetts, giving the court, or giving Special Prosecutor Hank Brennan the benefit of the doubt. I am no longer feeding into the bullshit that they continue to shove down our throats and say, take it. You are ostensibly, in my opinion, not providing Karen Read with a fair trial. You are preventing her from, like, the counsel, potentially her counsel of choice, potentially the rock solid bedrock of her defense in ARCA, and you're doing this methodically. You have challenged every single expert that we only had, frickin' 3 of them. Well, we had Dr. Sheridan as well, but like, this was always an unfair fight. It is always going to be a Commonwealth, or the prosecution has more resources, has more leniency from the court. But this has been an unfair uphill battle that continues to be less balanced every single day. It is like a 90-10, in my opinion, in skew of prosecution. It's disgusting. It's deplorable. And we now need to not take the high road. You go low, I will go lower. I will go to fucking hell. Because this is about justice. And a woman's life is in the balance and has been hanging there for years, while the Commonwealth continues to just bullshit their way through all the obstacles with an unfair advantage in Judge Beverly Kenon. So now, this was my tipping point. This is my spice meter. This is my call me sporty spice, bitch. I don't know who I am, but I am no longer going to be a kind of a person who is like, oh, oh gosh, I feel bad. And I know that they really are trying to do the right thing. Nope. You've proven to me for the last time who you are. Right? Like, we can continue to go around and around in a circle with this Commonwealth, with this Norfolk DA's office, with everything. Change is at our doorstep, everyone. Change is here. It has arrived, and we need to meet it with the same fucking energy that is given back to us. I meet you and I raise you 10 bitch points. I am not happy with the clear bias, the clear misrepresentation of facts, and an ability to be unchecked by the court. This is, we are a country of law and order. And there has been nothing of that sort in this case, in my opinion.
know what's being referred. It's not the point I wanted to make. And Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials just saw. Got them from the federal government. It's not a statement that he got them from the defense, which is a fact. And then we got new materials, but qualified, just some. But these materials were the very reason why the defense should not be able to call witnesses without giving full discovery. We had given full discovery. We had given it. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but some ARCO, the witnesses themselves, and recent requests for. So he's saying, this is what I got from the defense. And where do I discover? But I got this information from the defense, and he really got it from the defense. There's email correspondence between the defense, but not only the defense and the federal government, but with the ARCO witnesses. And then he goes on. But if we look back earlier in the relationship, what we see back in March 22nd, 2024 is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCO witnesses. And then he goes on and he reads the email. But the clear import of the point here is that the Commonwealth is saying right here that this is when I discovered these emails. This is how I got them, not from the defense, but the federal government. And we know now that that's correct. Then we proceed down to page 57. The Commonwealth, as I understand it, was not aware of any promise, rewards, or inducements or payment. They relied on a reciprocal discovery order of this court for that information. That's a misdirection. That's a misdirection.
Yes, it is.
There was no promise, rewards, or inducements or payments before all of those documents that the Commonwealth is referring to here.
Duh.
That didn't come until the invoice came in July.
Yep.
And it wasn't even a promise. It was pursuant to the conversation of Assistant U.S. Attorney Deutsch that, yeah, you guys got to pay it, and it's okay to pay. So next, on page 57, line 11. He reads, response, hi, Alan.
I fucking love you guys. Are you joking me? Someone wrote, all pearls on the table. Clicking balls says all pearls on deck. Yes. We've got our pearl earrings, we've got our pearl necklaces, and we are putting, all pearls down, all in.
Subsequent to our conversation on Wednesday, this is, I think he's reading from the March 22nd, but one of the disquieting aspects of this February 18th discussion is it's not chronological, doesn't have dates, so it's kind of hard to follow, but it certainly gave the impression, clearly, not the impression, it was stated that these came from the government, and I'm going to get to it when Your Honor was asking very apt questions about dates. But this is a very interesting paragraph. Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward? Your Honor, I'm going to please ask you to turn back to tab 1 of my notebook, because this was a purported quote of the March 22nd email.
But he forgot.
It's really not close to what the email says. It's not totally incorrect, but here's what I'm going to do, Your Honor. I'm going to assume that the court reporter's transcription was not accurate, and Mr. Brennan accurately, so I'm going to give Attorney Brennan the benefit of the doubt, because I can tell you that I've had my statements in court not completely correctly transcribed by a court reporter, and unfortunately, sometimes it's been on some key things. I don't think this is key at all, but I just note it. But it says, Mr. Brennan goes on, now it's the opinion that troubles me. It's relationship, and the Commonwealth should have an even playing field. That's number 4 of the time he's not having any trouble with the ARPA experts. Saturday, June 22nd, Daniel Wolf wrote, Alan, I spent some time this morning putting together a brief outline of my qualifications, blah, blah, and this is just a repeat of what we have already heard. Here now comes the important points. Page 58.
The most important point. Lawyer's daughter says he forgot the pause. Pause is what Dr. Wolf said to Alan Jackson in March of 2024. That's huge, Hank. And that's why there was no additional communication.
Line 2. Now, this isn't information provided by the defense in reciprocal discovery. Oh my. This isn't information. She's talking about all these emails. This isn't information provided by defense in reciprocal discovery. This is information provided by the federal government after numerous requests. And an insistence, the best I can, to get as much information as I can. It's incorrect statement number 2, and it's an important one. Down below, unfortunately, it gets even more incorrect. Defendant provided an outline of questions and answers for the direct examination. Please put this in context, Your Honor. The Commonwealth appears to be believing that they got the information from the federal government, not the defendant. So they got the outline, and they're now accusing the defense of having essentially drafted the outline. Defendant provided an outline of the question and answers for direct examination. Why? That's not fact, but if that were true, that would be very bad.
So what I'm going to do, I had no idea it's this late. So it's 1 o'clock. We're going to break for lunch. We'll stop back up at 2.
Oh.
Do you think, I have no idea how much longer you're going to be, Mr. Alessi. Do you have an idea? And I'm not rushing you. Do you have an idea? Because we do have the other motions. If we can't get to them today, we'll spend those 2 days next week with them.
I'm going to answer your question. I think I can conclude in 45 minutes because I have to get to the law, the 3.3A.
Yes.
I'm not rushing you. I just wanted a time
That's my
frame.
best answer, and I will say this, Your Honor. I share your interest. I'm presenting some of these motions.
But here's the thing, guys, is when Judge Kenon takes that stance with Attorney Alessi and says, I'm not rushing you, but yes, you are. Like, you're asking him, how much longer is this going to take? Because we have other shit to do. And I would like to be knee deep in clams down the Cape. Okay? We know she's not going to see Teresa in Newton to get her hair done, but she's got other things that she needs to do. Her and Jim need to immediately go to Staples. Get themselves a new printer. Okay? Maybe a stapler. I don't know. What I would like Judge Kenon to do is really take some more time to reflect. Enjoy a little romance. Go out to supper. Have a candlelight dinner. Maybe have someone send you a fucking edible arrangement. But you seem very, very unhappy on a regular basis when it comes to doing your job and providing a court and an environment in which any counsel is able to argue their points without you getting in their head and saying, she's done with this already. She wants no part of hearing me. I counted 6 times that she inferred there was an issue with time management. There was another 4 times during Mr. Alessi's speech and his argument, rather, that she corrected him in ways of not actually correcting, but saying, I don't like the tabs, so I'm going to look at my own material. Oh, that was a comment that's needed by the court? Ma'am, you appear to be showing your bias. It's hanging out. Cover it up. Or maybe don't cover it up. Because we've all known it's been there. But this is over the top, in my opinion.
And I have a strong desire not to be back here for that. So I share the goal, believe me.
Okay, so we'll see everybody at 2:00. You are muted.
Oh, we'll see you right at 2. Boop, boop-a-doo. Like, oh, I'm so sorry. You just started at 11. I know it must be very tiresome. Only fan. I swear to God, guys, if this does result in Alan Jackson being removed, we're getting a Feet Finder account. We are going to, and I mean, God, there is not a market for my toes, but I'm sure that a lot of you have beautiful toes. Okay, I look like I'm yabba dabba doing. Me and Fred, call me Kimmy Flintstone, because yeah, it's not the cutest. But if we have to go all in and figure it out, we will.
Okay, thank you.
Thank you.
So also, in big bold letters, at least on the printout, the subject is Karen Reed ARCA reciprocal discovery. It's not
Ooh.
like it was buried what was being said. I mean, this was a lot of things, but it's right there, ARCA reciprocal discovery.
And that was huge, because here's the thing, is babes, if you've watched other trials and if you are someone who is very interested in legal issues previously, right? If you watch ID and you're thinking to yourself, shit, put 5 women in the FBI that have had cheating boyfriends, we could solve any cold case in the United States of America and beyond, okay? I would also take Germany and Brazil. I would be able to be an international, incredible analyst. I find everything. I am an investigating queen, okay? Now, I say that to say this. Sometimes there are issues with discovery that get lost in the sauce. Last week, we talked about, did Adam Lally happen somehow to have gotten an email from Liza Little, and it just was in his email, and then he had to put himself back in his cone of shame, and he sat there and he thought about the worst thing that he had ever done in his life in 3rd grade when he, peed on the classroom floor of Miss Critch, right? And she made him stay there, and everybody laughed at him. And from 3rd to 6th grade, he was known as Pissin' La, right? They were like, Lal, you pissin'. Stop pissing, Lal. That's what they did to him. It was horrible. He was tortured. But that's a made up story. And this is something that is real. That discovery is hard to keep track of in a several year-long, investigation, then into trial, pre-trial, and to trial. But he made the point that this was one specific email named Karen Reed ARCA reciprocal discovery. This was absolutely not any kind of like even could be considered being put or hidden or sent somewhere it wasn't supposed to, or CC'd to someone it wasn't supposed to be CC'd to. No. Direct, straightforward, and only contained ARCA reciprocal discovery.
Was it just these pages that we've been talking about, or was
Ooh.
it a lot more discussed?
Oh my gosh, guys, I'm so sorry. First, and oh my lordies. I'm sorry, Loveromi with cheese. I didn't see this. Why? She's got bleach in her head. Okay. She was out for 3.5 hours last night trying to get blonde. Romy says, I hope the defense motion to dismiss addresses Brennan's reckless actions last week. Yes, my queen. Bev should have stopped him immediately instead of allowing him to proceed without a motion or affidavit. The prejudice caused by his lies is irreversible and the damage is done. Romy, babe, you know I'm obsessed with you. You are correct. You are the smartest and the prettiest. You know this shit. Okay. I also believe that there is no remedy for this. Okay. The prejudice that was caused not only by Hank Brennan and his misrepresentation to the court of material fact that fucking matters. It was also that it was all based on an oral argument and not a scintilla of proof or documentation that backed up what he said at that podium. And Judge Kenon recessed and then suspended proceedings. Horrific. It was horrific. And the damage that is done is irreversible. I agree. There is no remedy other than to recuse. Okay, here, this is what you could do. You either A, dismiss all charges, or you B, recuse Judge Kenon immediately, and you recuse and get rid of Hank Brennan, special prosecutor. He has done nothing to add to the Commonwealth. There is no case. There never has been. So you hire a defense attorney with a grudge against the federal government, and you get him to be your henchman, who has cost Karen more money than Adam Lally ever would have dreamed of. He is draining Karen's resources. He has caused spectacle in the court, and local media and our commentators, legal commentators, have literally disappointed me so much by taking a firm stance and not looking at the history of these attorneys that this is being alleged against. How dare you accuse Alan Jackson and David Yannetti, our hometown hero, of misconduct? That is not true. You have risked their reputations, their careers, and the most important thing that you have done is risked Karen's life. Fuck all this noise. There needs to be action, and it will be taken by either the Supreme Court or wherever it needs to go. So that's why today, on Karen's birthday, her birthday, where should she be? St. Thomas. What should she be doing? Getting, a tan? Feeling froggy in some blue water? I don't know. Is there a cabana boy? Just saying. Have a nice beveragino out of a coconut. But no, I'd bet my bottom dollar that Karen is on her computer, that she's looking up legal precedent, and that she's feeling the support from us, but also the weight of the world and the weight of the Commonwealth and their bias. And you're still fucking coming at her. It's disgusting. And it's improper. And I'm pissed. So yes, I hope that is brought up next week. I would give anything to be there and like just provide all of my positive energy and like, I don't know, just do anything that I could, because I have a feeling that part of that motion to dismiss is going to be the best shot that we have to get this done in lower court. And if Judge Kenon knows what's really happening and she can see this for what it's worth, if she could actually take a step back and see, I am not doing the right thing here. Hank did make a material misrepresentation multiple times. Then it would behoove her to make the right choice. It's still not too late to make the right decision. And I know that she hasn't every step of the way thus far. But when there's enough proof and enough evidence and enough fact to back up what the defense has put in their motion, then I believe the only thing to do is to dismiss all charges against Karen Read. Oh, and oh, hi, Kelly Reed says we just broke $700K in Karen's defense fund on her birthday. Thank you all for your generosity. Free Karen Read, and love your face and your hair, Kim. Oh my gosh, I love your face too, Cal. Everybody, this is huge. This is huge. We just broke the $700K. I would be so happy if we could maybe get her by the end of the day to 725. I know we can. And then sky's the limit, because we see additionally, guys, that this is not letting up. The prejudice and the persecution of Karen Read continues every single day, every day. And like I said, Hank is here as the enforcer, as the henchman, to drain Karen of her resources, to try to strip her away of her team, and to try to do anything in his power to make this flimsy, non-coherent, doesn't make even a burden of proof, in my opinion, this case. Doesn't meet it. There's so many holes and so many mistakes and so many worse things that went on, that all we can do is sit here, and your part is your part. Whatever you choose to do, Lovey, I totally understand. This is a group effort. We are a community. We will not quit. We won't back down. And when you keep coming for Karen, it's a direct hit on every single one of us, because it's Karen today, and it could be Kim tomorrow, and it could be Kelly on Thursday or Friday. Next week, they're coming for our daughters, our sisters. Enough is enough. Karen has fought this battle bravely, effectively, and handled it with so much grace, and shows up every day to fight. She doesn't sit down. She doesn't lay on the couch. She isn't watching fucking Love Island. She's tuned in, dialed in, not only for herself, but for all of us. So we tune in for her. I'm so happy about that, Kel. And Pam McKinnon, thank you so much, Lovey, says this bullcrap ARCA has proven Officer John O'Keefe was not hit by a car. Yes, Absolutely. Oh, and Pam, thank you so much again. I can do 4 + 5 and 1. Good luck. Does anyone want to match $10? Happy birthday, Karen. I love that idea. That's awesome, Pam. You're the best. And Miss Smith, sorry, just said, I think we should, I still think we should divide and conquer. Each take a hearing or a day of the trial to highlight all the misrepresentations by the CW, perhaps with a special emphasis on Hank. I love that. I love that. And I have gone through a lot of testimony and retestimony, and I have notes everywhere. You know this. She's a wackadoo. So I have, I think, 3 different subject 200-page binders that were from the trial and post-trial. And and hearings now. So I continue to document what I can. I have questions that I believe would make sense to ask Dr. Irene Scorti-Bello, the medical examiner, as well as Renee Stonebridge, the neuropathologist from the OCME in Massachusetts. Our quadruple board certified green queen, okay? She is the key. Arca and Dr. Stonebridge solidify Officer John O'Keefe's injuries being inconsistent and inconceivable with a pedestrian strike, in my opinion. All right, babe. Sorry. I got on a tangent. I love you.
Yeah, before we come, I know the answer.
It was just the pages, Your Honor.
Okay, thank you.
So it's not like this, ARCA is amidst a sea of other topics, right? This is the driving force of the email. And so, Your Honor, the question, and I'm going to keep moving on, but the question becomes, and I'm going to ask it more than once, but hopefully not too much. How is it that the Commonwealth on the 18th understood incorrectly, I think it's undisputed it's incorrect, that they got these materials from the federal government? We don't know the answer to that question, but I respectfully submit it's an important question. Was it an honest mistake? Was it just, as happens sometimes in lawyers working together, there's a lack of communication, there's a miscommunication? Is that the explanation? But I think truth and justice on these topics, since we're being so exacting and appropriately so, we should have an answer to that question. So we move on to page, so there we have on page 58, we have another incorrect statement.
Ooh, you don't say.
Right up off the top. And then we continue on to page 59. Your Honor, understandably says the court. What is the date of that? Mr. Brennan. It's not dated.
What was I talking about?
I believe, Your Honor, you were talking about the outline.
Just give me a second.
And Your Honor, if I may, I want to give you the second, but the basis for that answer is page 58, line 7, where the statement is, and what follows is all about the outline.
Okay.
So, Your Honor, appropriately and understandably says, what's the date of that? Here's the answer, Your Honor, got. It's not dated. It's not dated.
Now, we had talked about this last week, babes. This was another misrepresentation by Hank. And we said, in what world do you not receive an email that your attachment is clearly noted at the top of the email, which would state outline, which is what attorney Alessi says right here. That misrepresentation is so imperative, in my opinion, because Hank Brennan got up in front of the court. Now, he's a seasoned attorney, a very educated and capable attorney. I might not agree with how he does things, but he sure as fuck knows better. You do not get up and make an argument alleging not only Rule 14 discovery violations, but alleging that there is misconduct on behalf of the defense team, including Alan Jackson and David Yannetti, without there being 100% proof in what you are providing to the court. He misrepresents it as saying it came from the feds, it came from the defense, and then he says there's no fucking date on something. I'm sorry. Are you new? What are you talking about, Hank? That's dumb. Stop playing dumb. And again, this is where the prejudice comes from, guys, and that we sit and go, and Judge Kenon only took this and said, we're done here. Oh.
Let's please just go back to tab. February response, but they, and I'm assuming the Commonwealth meant the federal government, send random documents. There's no real accounting. But there is an accounting on the face of the emails that I
Let me
just
actually
went.
hold that thought. I just have one other thought.
Yes,
So
please.
we're talking about Saturday, June 22nd, what was sent as an attachment with the email, and Sunday, June 23rd. So this was before the witnesses testified, right?
That's
And you were
correct.
saying that this was disclosed prior to the February 18th hearing, but was this disclosed prior to the witnesses' testimony?
The answer is no, Your Honor.
All right.
Shut up. Shut up. Shut all the way up. Shut up all the way to the top of Mount. Shut the fuck up more. Shut up. I am so pissed when she asks that this June 23rd email was not disclosed before ARCA testified. The next day, when we are receiving Sally Port video from Canton Police Department 3 years later, get away from me. Get out of my zip code. Get out of my region, okay? Get off of my planet. The Earth cannot handle this. Find yourself another planet. I believe Uranus would work. And I want to maybe remind you of something that was said by Alan Jackson in trial 1. On June 18th, 2024, he got up and said, hey, Judge Kenon, cool. I totally get that you want to talk to ARCA, and I see that. I get it. But you realize that Adam Lally and Tully had an entire interview with Jennifer McCabe, and it was not disclosed to us until after she testified. Oh. And that information came out in her testimony. There was no new information that came out from ARCA. Everybody can get up in arms. Everybody can, do a circle jerk of trolling, but no new information came from ARCA. Nothing changed from their report that was furnished for the federal government. Period. End of story. You know whose testimony and new evidence comes from? The Commonwealth. And the Commonwealth only. Oh, very interesting. So interesting, Shazabi, that you ask me that. Nurse Kim, do you have anything in your pocket for Judge Bev? Well, I'll be dipped. Let's check. Oh, I just was looking over here and I just found something for you. It's right here. Okay. Don't spend it all in one place. Sorry, pardon me. Oh, I'm so fresh. Oh, gosh. Sorry, I'm fired up today, guys. And I do have a little something that was said by Judge Kenon that I felt was relevant.
And we want the other folks up here from Pennsylvania this week as well.
We'll make those calls.
So we need to pick a day. How long do you expect the voir dire of each of these witnesses? If, in fact, the defense has not spoken to these witnesses from Pennsylvania about the nature of their opinion, you must want it too, to be able to question them. How long do you expect the voir dire of each of these witnesses to take? I went and told the jury last week, last week that we were going to get them this case by the end of the month based on your representations, which included voir dires. It looks like at least a day of voir dire hearings here.
Yeah.
Yes.
Oh. Now, isn't that interesting? Because if we go back and we turn back the hands of time to June 10th, where that clip was from, and the allegations that are entirely made by the Commonwealth regarding ARCA was that there was no communication regarding opinion, their opinions, because the defense had it all. Their opinion was contained within their report. They hadn't spoken to them about that. And Judge Kenon mentions that there was a desire to have the case to the jury by the end of the month, by June 30th. They did it. Wow, I'll be dipped. They end up getting the case on June 25th for deliberations. But the representation that there was going to be a need for a voir dire was brought to the court by the defense. Shocking. Shocking. I'm sorry, clutch your pearls and clench your bunts, my babes. That is what Judge Kenon just said in that clip. That you represented that we would need this much time, including voir dires. Let's listen to it one more time. It's 47 seconds, 44 seconds.
And we want the other folks up here from Pennsylvania this week as well.
We'll make those calls.
So we need to pick a day. How long do you expect the voir dire of each of these witnesses? If, in fact, the defense has not spoken to these witnesses from Pennsylvania about the nature of their opinion, you must want it too, to be able to question them. How long do you expect the voir dire of each of these witnesses to take? I went and told the jury last week, last week, that we were going to get them this case by the end of the month based on your representations, which included voir dires. It looks like at least a day of voir dire hearings here.
Yeah.
Yes.
Yes. Yes. Oh, Jesus. So those lying sons of bitch bastards defense were in agreement with the voir dires. They thought there needed to be voir dires because they were unable to prep with ARCA. They were unable to prep with ARCA, babes, and they didn't prep with ARCA. ARCA did their own prep, sent a little Billy out, okay? And the Billy ends up where? At Alan Jackson's house. He says, what the not his house, his office. You know what I'm saying? This is my house. It ends up at Alan Jackson's office, and he goes, I'm sorry. What are we doing? We're not fucking. What are we doing here? And we find out that the U.S. Attorney's Office says, oh, Tag, you're it. You can pay for it. Bitch, we didn't talk about that. And here is the most evidence, in my opinion, full stop, showing who ARCA was contracted, hired, retained, and delivered a report to by none other than the one and only Crash Daddy Mac, okay, the Daddy Mac of the crashes, Dr. Wolf.
This, due to the confidentiality of it, only those who had access to the material to the file were allowed to review it and discuss it. And essentially, Scott Klein served as kind of another reconstruction expert to essentially bounce ideas off of and help with the review.
So for lack of a better term, sort of provided, let's say, sort of technical review of your work and Dr. Rensselaer's work, is that correct?
I would say assist us with the analysis, yes.
Now, so your firm and your agency issued a report in relation to what you did, correct?
That's correct.
And you've obviously had a time to review that report as far as what's contained in there factually, as well as conclusions and opinions, things of that nature?
Yes.
So is it your testimony that anything that has to do with anything factually, conclusions, opinions, or otherwise, in relation to the motor vehicle damage, those are your opinions, those are your conclusions, correct?
I would say that's fair, yes.
And again, based on the evidence that you will provide, correct?
Correct.
And so the facts or evidence or conclusions or opinions related to injuries to Mr. O'Keefe That was Dr. or Mr. Rentschler's area, is that fair to say?
Dr. Rentschler, yes.
And again, that was based on the evidence or whatever he was providing, correct?
Correct.
Which would be the same materials that you had testified that you had reviewed, correct?
Correct.
Oh. Oh. You don't say. I can't. I cannot. I shall not. And I will not. Dr. Wolf is schooling Adam Lally, showing him what's up, telling him, hitting him with all the goods. And he asked the questions. The questions were answered. You know? And I, Nan, woo, I choke. Hands up. Oh my gosh. Stop. Woo. Okay. She's going down. Only Nan. Stop it. Oh, that's my Loverobi with cheese. I just can't. Only Nan. You needed to hear you today, Kim. Keep shining. You keep shining. Stop it. That is too kind. Look it. I'm going down. So look it. Is Chloe driving the car home right now? What are we doing? That is too kind. I appreciate you so much, Nan. Are you coming to Pearls and Girls on Sunday? Somebody told me in the chat of last stream that you wanted to come. If you want to come to Framingham, I'd love to have you. Just let me know. Send me a message. I feel like I would love to have you there. I know that that's only what it's going to be on the 2nd, which is Sunday. That's pretty short notice. But if you want to be here, I know that Loveromi with Cheese is coming. Gigabyte Me Bev, Kelly. And I know Estee's coming. We have so many. Beatrice is coming. My Mimi is coming. I don't know. It's gonna be a pretty sweet lady event. Larry Legend has been invited. Shall he join us? I don't know. But I literally would love to have you. And I can't, you're too generous. I appreciate that so much. I'm passionate. I'm worked up today. I get a little bit sassy, a little bit spicy, and I don't mean to, because I try to give the benefit of the doubt. I try to pull a Robert Alessi, but I have none left. I have none left, Nan, and you know that. And you have been suffering. I've seen what's been going on the Twitter. I know it's a cesspool. I support you. We love Larry Legend. He is our Dragon Slayer. I know that you can do it independently, but it's annoying. It annoys me. It annoys me when people are believing that they're getting wins when there's a woman's life. Karen's life remains in the balance. And I don't give a shit. Not one single solitary shit. Poop emoji. If you don't like Turtle Boy. Okay? Get a life. Try to live it. But if you can't objectively look at Commonwealth v. Karen Reed and at the very least see a horrific miscarriage of justice due to the investigation that was a farce, a sham. Evidence that was not correlating or connecting Karen to any scene of 34 Fairview until her car was in the possession of Mass State Police and returned back to the Canton Sallyport. There is no blood on her vehicle from Officer John O'Keefe. There is messages from a girlfriend who is bullshit, waiting for her boyfriend to answer the friggin' phone because she thinks he's out playing hide the salam. And she'll never get this time back, Officer John O'Keefe will never get his life back. And all these fuckers, all 18 of them, are concerned about is like semantics and being right, or thinking, oh, this what, like everything is the end of the world to them. And this is it. This is it. And I'm like, holy shit, you are unwell. You should probably seek some therapy. I mean, we all could benefit as humans from therapy, but there are certain people that would really benefit. You know what I'm saying? So anyway, sorry. I love you. I appreciate that, Nan, so much. You're an angel face. Okay. So now we are going to move to Hank Brennan because I just want to talk a little bit of SHIT about him. Let's look at the only fan because we love Only Nan. Are we the fans of Only Nan? Yes. Yes, we are. Is she now our actual attorney at law? Because we lost attorney Mark Betterow? Yes. Is she an incredible asset with eyes and ears and mouth and nose? Yes. Okay. She's got it all. But the most important thing she has is a brain, and she uses it. And she's able to tell us, break down for us the things that we used to be able to, kind of have from our attorney, Mark Betterow. He has been called up to the big leagues from the AAA. We hear it, we feel it, we accept it. We got a pretty sick replacement. Another team, another teammate has been formed here. And for what? For justice. That is the only reason that Nan goes on any of our shows. She doesn't need us. That's for shit and sure. She doesn't need to have assholes give their opinion on her and her life. Nope, no thank you. It would be easier for Nan to sit back and say, oh, geez, that sucks. That sucks what's happening in Massachusetts to Karen. I don't think she's guilty. Great. I don't need to talk about it with anyone. But she chose the hard road. And she chose to be somebody who is there as a resource for us. And as somebody who has the specialty in law that she has, it's important. Healthcare and law are so commingled. And me, with my legal nurse consultant, I live for that. But I'm not a lawyer. And she's able to bring it that extra mile. Just like Melanie. Melanie, incredible. Angel face. I like to see the ladies. You know what I'm saying? Okay. Now let's do this.
Both sides. Coming in at the last hour and providing information when the avalanche started is not enough. This isn't just about Rule 14. My effort with the ARPA witnesses from the beginning, and I've been clear and insisted is not to preclude them, is to get fair discovery that we're entitled to. I did not know before a few weeks ago what the defense had known. I did not know that there was conversations and efforts made between them, and then inevitably conversation made. I didn't know that, but I certainly suspected it. I saw your Honor's questions before voir dire, during voir dire, after voir dire. I remember the conversation. And those questions were.
He's a liar. He's a liar. And it would be karmic justice for his pants to spontaneously combust onto fire. Okay? Didn't happen. But wouldn't that be something if it did?
Right to the point. And when we were sidebars, specifically mentioned, I don't know. Voir dire is inconsequential. I don't know what to ask. I can't send them back home and get their records of the emails or any billing. All of that was denounced. All of that was portrayed as baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete.
This is what chapped my ass. Okay? This is where I begin to put me in a Johnson & Johnson baby powder lawsuit, okay? How dare you, Hank Brennan? How dare you say that you have just scratched at the tip of the iceberg and that this is not complete? You're again making a material misrepresentation to the court. Who the fuck are you to say that there is more communication than what was provided? Why in God's green earth would Alan Jackson, David Yannetti, Liza Little not provide everything when they provided it to you on the 13th? And then they saw the overreaction and overcorrection and inappropriate ruling, decision, unilateral decision made by Judge Kenon last week to suspend the hearing for the rest of the day. Gave everybody a week. They turned everything over that was discovery. Mr. Alessi puts together his 8-tabbed binder. Beautiful, high quality, high class. You wouldn't know anything about it, would you? But he does that. And now you're again saying that they're lying. And that is in bad faith, Hank. In my opinion, there is no other rationale or reason that you can say to yourself, oh, Hank must have thought you. No. Just because you've made up a conspiracy between the federal authorities and the defense counsel and ARCA, because apparently you're having some kind of nerve and a synapse malfunction in your brain that doesn't understand that the report came from when the feds had retained, hired, and completed their report and was provided to the court, to the defense, and to the prosecution at the same time. Nothing has changed. And yet he's still going to push further. Hank, that's very skanky of you.
There is a murky relationship between the defense and the United States Attorney's Office relative to these ARCA witnesses. And there is a very unclear relationship as we stand here right now between the history of interaction between the defense and these ARCA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time. The pause moment on March.
Bitch! Yes. Oh, pardon me. Okay, don't say that, Kim. Damn it. Of course, there is enormous gaps in time at that pause moment on March. Oh, you don't say, Hank. So when Dr. Wolf said, we have to pause until the federal government directs our future involvement, whatever that may be, and then they are able to come and to do a voir dire in June. I don't understand how that is difficult. You read and know that response was received. Oh.
March 24th and reinitiating on May 5th, where ARCA is actually billing the defense for their works before the voir dire. There had to have been communication between that time that rekindled this relationship.
Nope, you're wrong. You're wrong. You're dumb and you're wrong, and that's rude, and I shouldn't say that. I will say, at least for our fathers tonight, and I apologize. However, what are you talking about? I don't know what exactly the line items are, but I know that I don't trust Hank's recollection or dates because you haven't been great with him thus far, good sir. Pardon me for a wee bit of skepticism of what you're saying is included.
There are 2 requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an affidavit from either counsel or any of the counsels. We did not hear a word from any of them. According to Mr. Alessi, what you should do, what the court should do is go.
And ain't that some shit to say that you haven't heard from either of the defense attorneys? That is so rude. That is so low, in my opinion, for an attorney to say that to another attorney. You're insinuating, you're inferring that them not getting up in front of Judge Kenon is an indicator of guilt. Are you fucking all right? You don't think that their ability to sit at that table while this was going on was the peak of self-control and discipline that these attorneys have had in the last 60 years combined that they have been practicing, and that they have had no disciplinary actions, and for them to have to sit there with your smug little fucking chipmunk face right in front of them after you caused this calamity because of your misconduct, and have the balls to insinuate that Attorney Alessi got up there not because it was the right thing to do for Karen and the right thing to do for the team, but to insinuate again and further push a narrative of wrongdoing. That is garbage behavior. Oh.
The federal government now.
So just to be clear, I am not having ex parte communications with anyone in this case. So I'm totally rejecting your request that I do that, Mr. President.
This is the moment I was talking about, babes, when Hank just licked his lips in joy, okay? Looked like he had just seen a porterhouse from across the room, right? Like, ew, you weirdo. But this is when Judge Kenon says, I'm not going to be having any ex parte here, communication with the feds, right? She's not calling to ask if the communication occurred, and that is in support of the defense, because why would they have called the United States Attorney's Office had there been a prior agreement with ARCA for payment? Period. Point blank. Last week, Hank said, I called the feds. I was looking for information. So Hank wanted to have an ex parte communication with the federal government. Judge Kenon rejects it. And somehow Hank still walks out smelling like roses. We live in an alternate universe. This is the Twilight Zone. Somebody save us. Is Alfred Hitchcock punking us? I don't know.
You suggested that I call.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor.
You never asked.
But the point is, it's not incumbent on the court to provide the proof that the defense was given the opportunity to bring in today to clarify the record. Instead, it is the typical 101, blame everybody but themselves. There's no acknowledgement. There's no contrition. And there's no confidence that we are going to get all the materials that we're entitled to. To suggest that our
As a Catholic, I was offended. I want every Irish Catholic mother of two to clutch your pearls as you hear Hank Brennan, Hank Francis, Hank the Frank, say that they were going to get all materials and that there was no contrition shown by the defense team. Yeah. I'm sorry. I need to be resurrected. Resurrect me. Christ has died. Christ has risen. Christ will come again. How dare you talk about contrition, sir? Because you have shown none. You did not correct the record. You are an actual example of a walking asshole if I have ever seen one. You are in Webster's dictionary. Look it up. Walking asshole. That was Ash Wednesday. An asshole. A walking asshole. Okay? He is in the dictionary. His picture. Okay?
Parker's position did not change. It did change. Their opinions did change by the time they reached trial. It is not that the defense brought out that there was an expert lighting or crashes happen at night. It is the bias, the relationship that is critical. And that was hidden from the court, the Commonwealth, and the jury.
Well, wait. Okay. Now, and again, here's the thing, Hank. I'm going to need you to pick a lane, pick a struggle. You can't have all of them, babe. Last week, you said that it was because you would love to hear from Arca. That is not the problem. You just needed the discovery. And now you're saying it's not the discovery. It is the hidden bias and relationship. Talk about moving the bar. This is an unattainable goal for the defense to meet, because this slimy snake in Hank Brennan will continue to add his own needs for it to be met. Do you know what I'm saying? Like, he is doing anything he can. If you complete this, then he'll ask for this. It will never be satisfied. He will never be satisfied until Alan Jackson is removed from counsel and Arca is prevented from testifying. And we will do anything that we can, babes. Anything that we can for Karen and for the defense team to ensure that this does not occur. What will that mean? What will that look like? I don't know. Is it additional appeals? Will there have to be a shift in the actual team for a short period of time when if Mark Betterow is allowed on, because we know that Attorney Brennan doesn't like that either? Will we have Nurse Kim call David Yannetti at his office, because I don't know his number, and ask him as his non-consensual intern, what can I do? Yes. But Karen's going to need us to keep showing up. It is her birthday. And, you know, that defense fund, as much as $700,000 that was reached today on her birthday, that is so much money, you think, right? It's not. It's gone. It has been gone. Everything that comes in is like, it's like in, and then, I'm robbing Peter to pay Paul, and trying to stay up like ahead in any way possible. But these tricky pricks won't let her rest. And we need to be locked and loaded, ready to rock at any moment. We need to have other experts in the bag. We need to have the hours, the billable hours that are needed for all of these motions and hearings and things that keep going while Alan still has other cases and is flying across the fucking country 10 times this month because of Hank Brennan alone. Ugh.
It is the bias and the leaning toward one side that was not disclosed. The first trial was disclosed last week or 10 days ago. So let me offer a quick history. It is true, when I first spoke to the court, I believed the documents provided by the federal government, and I did correct that record as soon as I learned before court.
No, you didn't.
January 30th, 2025, the United States Attorney's Office responded to one of my 2 requests. They provided billing, including ARCA billing. It was billing for their reconstruction, but there was no billing provided for their preparation, travel expenses, trial testimony. That information was provided to both sides on January 30th, 2025. It seemed at that point that the federal government was being at least a little more responsive, although not correctly. No bills other than what the ARCA experts did in putting together their demonstration and their accident reconstruction. February 11th, I filed on behalf of the Commonwealth a motion to exclude the ARCA witnesses. On February 12th, the United States Attorney's Office gives us new emails. And those emails were between the defense and the United States Attorney's Office regarding their request to use ARCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolf, and the invoice of billing. Now, I did misspeak, I corrected it, but it is not the source of that information. It is the substance of that information that is critical and relevant. It is that
That's a lie too, right? Like, let's just wrap that up with him and say that you didn't correct it. You did a chronological order, and you did not say You only said that the emails that you read from the podium were from the defense. You did not say that the outline was. You did not say that the invoice was. You did not provide a date which was clearly documented on it. You did everything in your power to misrepresent information not only to Judge Kenon but to the media, to a nationally televised trial, and you are a tricky little rat. And everybody knows it. Everybody can see, Hank. Clutch your pencils and make an exit because it's embarrassing.
Information that should have been known to the court, the Commonwealth, and the jury at the first trial. And it is also that information when you compare it to the representations that have been made prior to trial by the defense that has input. Before, and I'm not going to belabor this, but your comments, most of them again, but it is important before I get to the representations. The court does consider pro hoc VJ. We have one licensed attorney in Massachusetts who's carrying 3 pro hoc VJ attorneys with the request for a ride on that same license.
And that is a direct threat to who, babes? This hurt my feelings because why? You know, I have a soft spot in my heart for David Yannetti. He's my favorite. I know. Stop it. Like you didn't know this. And I don't have favorites because they, but I do. Okay. His name is David Yannetti. And him and his dimples will always be my main squeeze, my number one man of the defense team. And I mean that with all due respect to Mrs. Yannetti. And I don't mean to be fresh, but, and by Hank saying that he has 3 attorneys on his bar license, right at the table, that's a threat to Mr. Yannetti. You're threatening David? Like, really, Hank? And saying that, so, okay, worst case scenario is AJ gets thrown off and then there's a bar complaint, or there is some sort of action on his license. Come on. This is wild that you're saying this and that there is no correction from Judge Bev.
Responsibility, especially to Attorney Yannetti, fine attorney, an excellent attorney who I admire. But there's a responsibility.
We admires him.
So
You show it weird.
Lawyers doing different things and then later plausible deniability. When we send emails, if I should miss one person on an email, I will receive an email telling me that make sure everybody gets every communication. I've been corrected or redirected many times when we've left somebody out on communication. Pleadings are signed by all parties. They come through the bar card on that table. And so to try to parse or mix or put a slight on words to suggest that things are done independently and there's no responsibility for the defense when a representation is made that's inaccurate isn't enough. It doesn't assure that in the future it won't continue. Now, Mr. Alessi said there were rules of the road. This was before his time and mine, but I've read the discovery. There were no rules of the road. There was a protective order. And the protective order was clear that there was no discussion outside of court about federal material. And there was nothing in the protective order or direction.
It was clear that there was to be no discussion of the federal materials outside of court, and they did that. They followed that because it was only discussed in voir dire. What are you getting at, Hank?
The U.S. Attorney's Office that the Commonwealth had any right or privilege to contact any witnesses. Everything is done by the book, by regulation, through 2 requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time, because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge, essentially, of what was going on. So I received those 3,000 pages plus. I did not receive a protective order. I don't know that I'm entitled.
Then they end up talking about that. And then Bev says, oh, I'm so sorry that I interrupted you. But in the multiple times that she did to Mr. Alessi, she didn't care. Next, there was one more thing I wanted to cover with Hank, and then we'll be done, babes. But I'm so glad I got to see you today.
Dave, I'm sorry. What's the volume number and the page number?
Oh, at least she's asking him for page numbers this time.
Okay. And you were asking about the 3 experts from ARCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. When we look at the ARPA report, there's no delineation on which of the three experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call. And so when you continue questioning, you were told, well, you said, so I'm to believe that the defense is calling lead witnesses that you've never spoken to and putting them on the stand. And Mr. Yannetti said that's essentially it. He gives some detail. As was mentioned earlier, we've spoken to them only for purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls two witnesses, Mr. Wolf and Mr. Rentschler. And when they only call Mr. Wolf and Mr. Rentschler, there must be a reason why. Because you can't tell from a report who did what. They noticed.
God darn, why do you make yourself look so uneducated when you say things like this? It is very simple. Go back to June 10th, and Mr. Klein was not a PhD, and he was not certified in accident reconstruction. He was not allowed to testify. I'm sorry. Are you new? Oh, you're new here, Hank. This isn't the trial to try to come in. You don't even go here. Like, stop. And Judge Kenon specifically says, when asked, who are you calling? And Mr. Yannetti says, we're doing 3. Alan Jackson corrects him and says, we're going to be calling 2 of ARCA witnesses, Dr. Rentschler and Dr. Wolf, because they are certified in accident. No, I lied. Judge Kenon says those are the 2 that are certified in accident reconstruction. Now, Mr. Klein is like, he has a bachelor's or a master's. I can't remember which one. He did work on the team, but how hysterical. And not really, because it's sad and scary, but you would not allow the third ARCA person to come and to at least do the voir dire, but you allowed Trooper Paul his associate's degree, which I'm not at all being, judgmental or critical on an associate's degree. That's great. His associate's degree and his 40 hours of training, his training certificate against ARCA. It's mind blowing. Every damn day, it's mind blowing.
The experts. So there must be conversations with somebody explaining the witness's role or why only 2 of those 3 witnesses are important for the defense. And so it is clear from the absence of information, there are much more communications that are expected to be in existence that have not been provided.
Doubles down and says that there must be much more communication with no proof.
2024. The voir dire hearing.
I don't care about that. Where does he say? Almost done, guys. I'm sorry.
Line 4. Importantly, when you
Look at Mr. and Mrs. Reed. Oh, hi, Cal.
Before this moment, when you walk in the court, you
Oh my gosh, I love your blazer.
Now, this illustrates an important point. That is technically true. But what impression is that making to the court and to the Commonwealth? Is that a genuine impression consistent with reality? Line 20, the person to my left, the female to my left sitting here, have you ever seen her before? Nope. You know who she is? Yes. And so there is direct and indirect commentary, questions, presentations that reinforce.
No, that wasn't it. That wasn't what I was trying to get him to say.
24. What we don't know is, in the preparation, was there any conversation with the defense? Was there any?
Oh, this is it. The bill. Sorry, guys. Bear with me.
From the United States Attorney's Office on February 12th, there is no billing related to tax for air travel, trial, none. So the only people who were surprised that they were paying the witnesses apparently was the defense themselves. And then before that June 10th hearing, where the representations were made, there's a June 9, 2024 phone call. Another anticipated telephone call down. And then we see before the voir dire testimony, there is billing to the defense, which now we know paid by the defense, prepared for voir dire testimony. June 17, 2024. What we don't know is
Prepared for voir dire testimony on June 17th, 2024. And at least in one iota of, I don't even know if I would say that it is honor or respect from him. He says, what we don't know is if the preparation for trial by Dr. Rentschler and Dr. Wolf was completed with the defense. I can guarantee you, I would bet my house, okay, that there was no preparation that occurred with the defense team. It is 100% appropriate for the expert witnesses of ARCA to review their materials in order for them to feel prepared coming in, being on a national trial, nationally televised trial, going to be, direct examined and cross-examined by the Commonwealth of Massachusetts. I 100% would be preparing myself. And I know that the amount of care, the amount of testing that they did, they built cannons, for Christ's sake. The ARCA experts are professional to the hilt. They were only retained and contracted via the FBI, period, point blank. Their findings were subsequently able to be used by the defense in this case. And any defense attorney would tell you that they would have done the same. Although this is a very unorthodox situation, yes, I didn't get to speak to them. Yes, I didn't find this attorney, this expert, and I didn't pursue this. But I was able to read something that was exculpatory to my client, and I want them on our team. There is nothing more impressive, more concrete than ARCA and their testimony in this case. That is non-negotiable. ARCA even blows Irene Scorti-Bello out of the water. And that's from a medical examiner perspective. Stonebridge, it's my girl. But their findings are what really is able to show the jury, show the Commonwealth, and prove that the injuries sustained by Officer John O'Keefe have never, will never make sense, align, correlate, or be medically possible, in my opinion, to have occurred or stemmed from Karen Reed's 6,900-pound Lexus LX 570. It didn't happen. Karen's vehicle did not go in reverse at 24.2 miles an hour in a straight line for 62 feet, and she hit a target, a human being target of Officer John O'Keefe. Where? In his arm. Like, the fact that even when we say this out loud, guys, doesn't it make your skin crawl that this has been brought to court for now a second trial with a woman's life, not only for a manslaughter charge, but for a second degree murder charge, has been, she's been indicted upon this. Where is the medical sense? That's what matters here. And it will never line up. The Commonwealth will never, ever convict Karen Reed.
in the preparation, was there any conversation with the defense? Was there any emails?
Okay.
They had their opinions and they were exculpatory. Our opinions changed. There were 4 opinions. And if you look at the report, And I'm not going to read it for the sake of the press and the public, which will have the trial, and we'll edit that trial. But when you read the report, clearly the representation made about that report were extended that trial. And the question is going to be, why? Why did they improve? Why did they?
They didn't improve. They didn't. Nothing happened there. Nothing changed. Everything is the same.
The question is, will we get it before trial? I have another 2 letters going out. This week.
Here's it.
I will take respond to it, and 2 letters aren't going to be thorough and complete. It's just not the way to works. And so we are in the same spot. Well, actually, we're in a better spot. We know now about the relationship. We know about the potential bias. We know about the payments, but we don't know the full scope of it. And so we are entitled to that information. We don't know what conversations, communications the defense had with the art experts that the federal government doesn't know about. Over the next few weeks, we're going to attempt to get more information, but we will never have an accurate accounting unless it's compelled.
There it is. That was my final point, babes, is that this is what Hank really wants. He again triples down, states that there is a probable or possible relationship between additional, then disclosed with the defense and ARCA, and that there is a murky relationship between the federal government and the defense team. He's tinfoil hatting this all the way to the fucking bank, okay? Conspiracy theory Hank is out and about, okay? Go home, get some rest, babe, because he keeps looking for Easter eggs, and it's not even that time of year, you know? Okay, you're a little early, okay? The Easter Bunny is not coming to your town, not coming to your house. All right. So he's demanding, or asking rather, for Judge Kenon to compel evidence that he does not know if it exists. I do not believe it does exist. I believe everything was handed over by the defense as it was initially in compliance with their Rule 14 for this trial. They have done, unless there was a different or a specific rule in this retrial, there is no reason that Karen didn't have this specific time frame, right? You always have the same time frame for every single discovery. According to Massachusetts Criminal Procedure Rule 14, the defense must generally provide discovery to the prosecution, including witness information and the relevant evidence they intend to use at trial within a time frame specified by the court. Usually after the prosecution has provided their discovery and on or before the first pretrial conference. Okay? And that was done correctly. The Commonwealth just filed theirs, and the first pretrial conference isn't until March. So there was no payment, nothing was made until after the first trial, which makes it what? Discoverable in trial 2. It was a payment that caught everyone off guard. Oops. Okay. There was no, nefarious intent on the defense. There was absolutely no nefarious, intent on the U.S. Attorney's Office. And the fact that he continues to push this narrative, just like Kevin Linehan from Yellow Cottage Tales, makes me uncomfortable to my core. If you and a man with a yellow cottage in the woods have the same opinion, that's concerning. Okay? The cottage is frightening. Don't go there. Okay? It's not a gingerbread house, Hank. Weird shit happens. Evil spirits. I've been told. One time I went there, fought for my life, 70 people.
Your Honor mentioned the sidebar.
Which one?
The most recent one.
Okay.
Oh, I don't care.
That they were going to be paid by
This is the only thing I wanted to show
the federal government doesn't know about.
when he goes to get up, when poor Mr. Alessi goes to get up one final time and to hear Judge Bev speak
Very briefly, if you have something.
Yes, thank you. I'll be very brief.
very briefly if you have something. Rude. And Mr. Alessi, he just hits him with the 1-2, lets him know that, again, we have provided our discovery. There was a material misrepresentation to the court by only one side, and that is the Commonwealth. Additionally, the prejudice that was done to Karen by Judge Beverly Kenon suspending that hearing in the way in which she did, based upon the information in which she made that choice, is very concerning. That shows bias. Okay? That's what I'm concerned about, Hank, is the bias for the court and the prosecution. And that you've never given Karen Reed a fair trial. So shove your number 2 pencils directly up your poop chute and keep your feigning and your concern for her out of your mouth, because it's never been about that. It's always been about working for, with, and to the Commonwealth to secure a conviction of an innocent woman. And on her birthday, we say, happy birthday, Ka. You got this. And we've got you. All right? We're going to ride it till the wheels fall off. And we're going to free Karen Reed. All right, babes. I love your face. This was a long one. I'm sorry. I was long-winded. But I wish you a wonderful rest of your Wednesday. Be good to each other. And I'll see you soon. Love your face. Bye.